Good afternoon, everyone. Thanks for joining our panel discussion on litigation, anti-Black racism, and the Trump administrative changes. This panel is sponsored by the American Bar Association's Commission for Immigration. And I would like to thank Tanisha Bowens for organizing and putting this panel together. So this panel will focus on how the prior administration made public hostility towards immigrants of African descent a point of pride. We have a panel today of advocates and lawyers who have been at the center of litigating and advocating to work against anti-Black racism within the immigration system. During our time together this afternoon, we'll examine the impact and effect of efforts by advocates, policymakers, and activists to address discrimination against Black immigrants, and ultimately examine how Black immigrants have largely been absent in discourse on the impact of immigration policy. This panel is extremely important as it comes on the tail of the Black Alliance for Just Immigration releasing a report entitled "The Impact of Anti-Black Racism of African Migrants at the Mexican Southern Border." And this report examines the particular harms that Black immigrants face on the southern border that result from their invisibility within immigration discourses and anti-Black racism. The panelists will discuss their collective and individual efforts to challenge many of the harmful policies, including the travel ban, which has become known as the African ban, the revocation of temporary protected status in DACA, and other topics that they have addressed through advocacy and strategic litigation. So that we can delve into the content, I will briefly introduce you to our panelists, and I invite you to go to the webinar website where you will find detailed biographies of our distinguished panelists this afternoon. Our first panelist is Ajmel Qureshi, who is the Senior Counsel with the NAACP Legal Defense Fund. Ajmel has filed lawsuits against the U.S. Department of Homeland Security in response to the removal of temporary protected status of Haitian immigrants. He'll discuss that litigation and other pertinent litigation against the prior administration. Second, we will hear from Ambreen Walji, who is the pro bono coordinator and staff attorney for the American Bar Association's Immigration Justice Project, who works with immigrants detained at the southern border in San Diego. And then we will hear from Alion Lee, the Secretary General of the Mauritanian Human Rights Network. This organization works with Mauritanian immigrants living in the United States and has been on the front lines of fighting for human rights, civil rights, and better opportunities for Mauritanians. So thank you for joining us today. I know it will be a fruitful and thought-provoking discussion. And so I'll turn it over to Ajmel. Thank you.
Good afternoon, everybody. My name is Ajmel Qureshi. I'm an attorney at the NAACP Legal Defense and Educational Fund. As you probably know, LDF is one of the nation's oldest civil rights organizations. We work on a variety of different issues related to reforming the criminal justice system, economic justice, education, justice, and voting rights. What I'm going to be talking about today is mostly LDF's work in the context of immigrants' rights, which is a core part of our racial justice work. I'm going to be talking about 4 separate cases, as Professor McAnders mentioned. I'm going to be talking a little bit about LDF's case related to challenging the termination of temporary protected status for individuals from Haiti. I'm going to be talking about the work of Howard University School of Law Civil Rights Clinic, where I also taught for several years, related to the challenge of the termination of the DACA program. And then I'm going to be talking quickly about the Muslim ban, as well as the border wall and the litigation related to that. At the end, I will touch a little bit upon next steps for the new administration, and over the course of the talk, I'll give you a little bit about some intro to some basic concepts of administrative law, which are central to all of the legal issues that we're talking about today. So as we know, the Trump administration launched a full-on attack on civil rights in a variety of different fields, whether or not we're talking about housing, education, immigrants' rights, police reform or the lack thereof, voting rights. All of those are issues that LDF and our partners in the civil rights field have been working on very hard over the last 4 years. One of the issues that I worked on while I was at Howard University School of Law directing the Civil Rights Clinic there was a challenge to the Trump administration's suspension and termination of the DACA program. As you probably know, there are roughly 800,000 people who would have been eligible for the DACA program. This is a program that would have affected individuals who were brought here as children and remained in the United States. The program not only would have prevented them from being deported, but also would have provided them other benefits, including access to health insurance and driver's licenses. The program has broad support among Americans. One poll indicated that 87% of those surveyed believed that DACA recipients should be allowed to stay in the country as long as they were working or going to school. Nonetheless, in 2017, then Attorney General Jeff Sessions announced the administration's plan to end the DACA program effective March of 2018. The program was swiftly challenged by a wide variety of states, universities, nonprofits throughout the country. I was involved in the challenge in the United States District Court for the District of Maryland. The crux of the challenge and many of the other challenges, including the ones in the Second Circuit, the Ninth Circuit, as well as in the DC Circuit, was that the termination of the DACA program violated something called the Administrative Procedure Act. Essentially, this governs what's called agency action. Those are the rules, the federal rules and regulations that agencies create. It's incredibly important. A great number of civil rights are created when we're thinking about the Equal Employment Opportunity Commission. That's an agency when we're thinking about actions taken by the Department of Justice's Civil Rights Division. Those are agencies. So agencies play a vital role in civil rights enforcement and civil rights protection. And for good reasons, there are limits on what agencies can and can't do, specifically on the processes that agencies have to use. The two primary means of challenging agency action, and this was an agency action because it involved the Department of Homeland Security terminating a program that would have provided benefits to undocumented individuals within the United States. The two primary means of challenges under the APA are what's called notice and comment. That's why before an agency acts, it has to give the public the chance to give comment on actions that it plans on taking, and then incorporate or at least respond to those comments before it acts. And notice and comment is tied to the main other type of APA change, which is an arbitrary and capricious challenge. That is, an agency not only has to respond to the comments, but it has to explain in a sufficient way why it's taking the actions that it's taking. And that essentially was the crux of the argument in many of the DACA cases around the country, that although no one disputed that the government had the power to terminate the DACA program, the question really was whether or not the government went about in explaining itself sufficiently. And what the Supreme Court found last year is that or actually it would have been a little bit more than a year ago, that the Department of Homeland Security had not sufficiently explained itself. The crux of the Department of Homeland Security's basis for terminating the program were questions regarding the illegality of the benefits that came with the program in terms of health insurance and access to employment, But as the court explained, the Supreme Court in a 5-4 decision, this was Justice Robert, joined by 4 other justices, the agency had not explained why those questions regarding the legality of the benefits affected its decision to halt the deportation program, portion of the program as well. So, and as we've seen over the last couple of weeks, a new administration has come into office. They've issued 17 new executive orders, and 6 of those have related to immigration. And one of the executive orders that the Biden administration put forward called on the Department of Homeland Security to come up with a new plan for DACA, which would allow it to go forward, while at the same time also calling on Congress to impact universal comprehensive immigration reform. So that's the DACA case, and that's where things stand right now. We're at an important place where not only are renewals allowed under the DACA program, but since November, new applications for participation in the DACA program are allowed. There have been 30,000 applications that came in since November. Roughly 2,000 of those were new applicants, and about 10% of those new applicants have been approved. So that's just one way in which we've seen immigration issues come up in the last 4 years, and the change that's happened with the transition to the new administration. The second major issue I wanted to talk about today is the quote unquote border wall that President Trump pushed forward, paired with the increased militarization of the border that his administration called for as well. On February 15th, 2019, President Trump followed through on a threat to declare a national emergency under the National Emergencies Act of 1976 and to invoke emergency powers in order to secure additional money for the construction of a border wall along the southern border. In total, Trump announced an intention to commandeer approximately $6.5 billion additional dollars that Congress had not allocated for border wall funding. He specifically invoked Statute 10 U.S.C. 2808, which allows for the diversion of funds for military construction projects where there's a national emergency that requires the use of armed forces. So that's the specific statutory basis on which the then president was relying. Not surprisingly, again, the language is national emergency that requires the use of armed forces. A number of civil rights groups, individuals, and organizations challenged that designation of those additional billions of dollars for a border wall under that specific provision of the statute. There was litigation in the DC Circuit, the Ninth Circuit, the Fifth Circuit, all raising the third type of administrative action challenge that I wanted to talk about today, which is an ultra-virus challenge. That's not there you are essentially not challenging the procedure, but actually challenging the agency's authority to take the action that it did. It's similar to an APA claim, but it's actually a distinct ultra-virus claim where you're arguing that the agency acted beyond the powers that it had under the statute, which designates it to act. What we saw in those cases is a number of courts, namely the Ninth Circuit, upheld a permanent injunction against the use of the emergency powers to fund the construction of the border wall. That ruling was on October 12th, 2020, and the new administration, the Biden administration that came in, as one of those 6 executive orders related to immigration, revoked the decision to go forward with the border wall. So for now, given that new executive order, the border wall building as well as that additional funding is not going forward. The third issue, and it's a long issue, as mentioned, I picked out 4 of the most salient issues that I've worked on over the last 4 years, but really these are just 4. I mean, I'm talking about the border wall, I'm talking about the Muslim ban, I'm about to talk about temporary protected status for individuals from Haiti, and I talked about DACA. I certainly don't want to say that these are the only issues or necessarily even the most important issues. There are many other issues, and I'll touch upon this at the the end that the administration took action on that harmed Black individuals in this country and Black immigrants seeking to come to the United States. The third issue that I want to touch on briefly today was the termination of temporary protected status for individuals from Haiti. Temporary protected status is a status that allows individuals who are from countries that have oftentimes suffered natural disasters to remain in the United States for a temporary basis. Haiti is one of those countries. Haitian immigrants to the United States first received temporary protected status in 2010 as part of the Department of Homeland Security's efforts to assist the country after it was struck by a 7.0 magnitude earthquake. Nonetheless, unfortunately, the country has been subject to multiple hurricanes and a cholera outbreak since that time. Accordingly, the temporary protected status for Haitian immigrants to the United States has been extended on a number of occasions. However, on November 20th, 2017, the Department of Homeland Security announced its plan to terminate temporary protected status for individuals from Haiti. We alleged in our lawsuit, and I say the LDF alleged, that the termination of the temporary protected status program for individuals from Haiti violated the Equal Protection Clause of the Fifth Amendment. So this essentially was a constitutional challenge. We've mostly been talking about APA challenges as well as the ultra-virus challenge, but now we're talking about a due process and equal protection challenge that LDF filed. We cited a number of incidents of hostile statements made by the Trump administration towards individuals from Haiti. We cited the then president's statement that all individuals from Haiti have AIDS. We cited his statements preferring that there be additional immigrants from predominantly white countries in Northern Europe, and asking why many of the immigrants that come to the United States are from predominantly Black countries like Haiti. We believe that those were strong arguments that the government's decision to terminate temporary protected status for Haitians were motivated by racial animus. There were a number of other cases around the country, one of which, the most significant of which, in addition to LDF's case, was a case in the Ninth Circuit brought by the ACLU called Ramos v. Nielsen. In that case, they were able to obtain an injunction at the lower court level, but the United States Court of Appeals for the Ninth Circuit actually blocked that injunction, which allowed the termination of protected status for individuals from Haiti to go forward. However, in December of last year, in December of 2020, the government decided to extend temporary protected status for individuals from Haiti until October of 2021. So that's where things stand right now with regards to temporary protected status for individuals from Haiti. Of course, individuals from Haiti aren't the only individuals who have temporary protected status. There are over 400,000 people from 10 separate countries that have protected status. Honduras has 80,000 TPS beneficiaries, followed by Haiti with 55,000. Nepal has nearly 15,000. Nicaragua has 4,500, and Sudan has around 1,000 as well. The fourth issue that I wanted to talk about today, and this perhaps might be the most frustrating of all of them, although it's sort of a subjective take, all of these are really difficult, tragic situations, is the Muslim ban, the African ban, the travel ban that you're probably familiar with as well. This came right after the then president came into office, building upon his statements during his election campaign that he would call for a total and complete shutdown of individuals, of Muslims entering the country. On January 27th, 2017, a version of the Muslim ban was issued, which banned individuals from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, all majority Muslim countries, from entering the United States. That ban was shortly thereafter preliminarily enjoined by a federal district court in Hawaii, which prevented enforcement of the revised order. That was appealed to the Ninth Circuit, where it was upheld, and then appealed to the Supreme Court. However, before it could be heard by the Supreme Court, the Trump administration created a third travel ban, which in some ways was sort of window dressing. It was seeking to cover up the animus, or as we alleged, behind the original ban. So it included additional countries such as Venezuela, North Korea, but also included Chad, Iran, Libya, Somalia, and Syria. That third version of the Muslim ban was also preliminarily enjoined. The government appealed to the Supreme Court, and in a 5-4 decision, the Supreme Court upheld the Muslim ban in a very frustrating decision. I think, from an advocate's perspective, I think what that decision really spoke to and what the Supreme Court relied upon is the tremendous amount of deference that's placed to the executive in the national security context. So I think there's a sense, at least maybe from some quarters of the public, that now that we have a new administration in office, many or almost all of the things that were wrong with our immigration system are no longer problems. And I think that's a little bit of an oversimplification. I think some of the things that the then president was able to do were a result of the tremendous amount of deference we give to the executive and the growth of the powers of the executive over the last 25 years, specifically in the military and national security context. And the decision, and if you look at the language in the Muslim ban or the travel ban case, I think what you'll see is a reflection of that tremendous deference and the dangerous nature the dangerous impact it has on immigrants throughout the country. What I've been talking about today is mostly immigration focused. I should mention that, again, one of the first things the new administration did after coming into office was rescind the Muslim ban, which was an incredibly positive first step. I don't have time today to touch upon all of the other issues that the Trump administration undertook and civil rights issues and laws that they sought to suspend or terminate. I do most of my work in the housing context, so there were rules that would have terminated or suspended increases in the values of housing vouchers. There was a great deal of tweeting from the president last summer related to then candidate Biden's desire to segregate or desegregate the suburbs. And that was seen in new rules barring or giving municipalities free rein to not desegregate. And there was a new disparate impact rule that the United States Housing of Urban Development issued, which requires plaintiffs alleging disparate impact, that's challenges to policies and practices that have or harm one group more than another, increasingly making that standard more difficult so that plaintiffs essentially have to prove the equivalent of intentional discrimination. Just a few more things that are out there to watch for. Family reunification, it's a huge issue. The new administration has created a task force to reunite migrant families. I think it's important that that task force acts soon. It's important to monitor actually what the results of that task force are. The new administration created a 100-day deportation limit on who could be deported. It's not a total ban on deportations. It imposes some pretty strict limits, which are important, but that was enjoined by a district court in Texas. The new administration issued an executive order calling for a review of a policy that made it harder for poorer immigrants to obtain permanent residency in the United States. It's important to monitor what happens with that new rule when it comes out and what it's looked like. And it's also important to look at what happens with President Trump's asylum ban. That's the ban that required individuals seeking asylum to return to their country or leave the United States. Individuals have been stopped, are no longer being added to that program, but it's unclear those who were ordered to return to their country or ordered to leave the United States, what will happen to them. So I've covered a great deal of information. I appreciate your patience and look forward to your questions.
Sorry, just setting up my PowerPoint. My name is Amberine Walgie, and I'm the pro bono coordinator and a staff attorney with the Immigration Justice Project, IJP. We're based out of San Diego, California, and we work primarily out of the Otay Mesa Detention Center, where we represent detained immigrants and try to match detained immigrants with volunteer attorneys. I'm stepping in for Lauren Cusatello, our legal director, and I'll be speaking more about the human impact of what we've seen in detention over the last 4 years. This quote, "Suffering is a part of life," was something that a Cameroonian asylum seeker recently told me. He wasn't describing the torture he faced in Cameroon or the journey through Central America or the family he left behind. What he was describing, sorry, I'm just realizing I'm not showing my screen. What he was describing was what it was like to be in detention and the pervasive racism that he experienced at every point of his journey to the United States to find permanency. He was describing how he was treated by cellmates, by prison guards, and particularly the discrimination and racism that all migrants face, but particularly those who are from African countries face and culminate in detention. At a time when we are trying to move away from a world where we think of Black men in jails and prisons, we realize that there's no distinction made in immigration jail between Black men and brown men, who we see in orange and tan jumpers in immigration detention, who have truly done nothing wrong and are victims of their circumstances. By virtue of their Blackness, Black asylum seekers stand out in detention among a population that is mostly Hispanic. Although these issues may not be unique to the legacy of the Trump administration, what is more pervasive is the further enslaving of Black and brown people from around the world that are fleeing human rights violations. Because the default is now to detain, or has been to detain for the last 4 years as a result of the change in discretionary policy, someone with no criminal history in the United States ends up in jail. The subtle and not so subtle racism is pervasive. In speaking with Black asylum seekers, one of the most prominent ways that racism comes out is through language barriers and the privilege that speaking a common language offers, and that speaking a common language offers by the system. The system is used to Spanish speakers, and Black migrants will tell you that the Hispanic population gets preferential treatment. They say most people are Hispanic, and so they're awarded more privileges. They get help and encouragement of guards and staff when they first arrived, and they have an advantage in every aspect. So we see that even among people who are united historically, it's true that when people end up in immigration detention, humanization as a result of their PTSD and what it looks like in immigration jail, they do tribe up. They form race-based associations that are true because of shared cultural and language backgrounds. Many Black migrants in detention will speak to how they are disadvantaged by virtue of their race and inability to speak Spanish during most basic interactions. It's not uncommon for a Black asylum seeker to report that they wait longer for meals at Chow, or that they have to make concessions to use a microwave. One female Black asylum seeker from Cameroon reported that at the Otay Mesa Detention Center, she was in the bathroom for a little bit too long, and a Spanish-speaking woman reported her to the Spanish-speaking guards, and she was penalized. She told me that from the moment that she got to the detention center, the guards put her second to her Spanish-speaking cellmates, who were offered better jobs, given words of encouragement, and opportunities for accessing relevant information to their release from detention. And she felt like she was fending for herself. She said, "They laugh at you because you couldn't speak Spanish. They believe that Black people don't know anything." From a deliberate mispronunciation of names by jail guards, to how late they're able to stay up, it's almost a policy that at the bottom of the stratosphere in detention is the Black asylum seeker. We see that the guards and the staff at the Otay Mesa Detention Center, which is a private contract facility, is not interested in doing cultural work around cultural sensitivity. And we do see that people who speak Spanish, because we live in San Diego, get this preferential treatment. And it's even worse, as I'm sure Eloise will speak to, for people from Mauritania, Guinea, or even Haiti, because they do not speak Spanish or English. These policies are unfair, and they always were unfair, but we see it more in the last 4 years. We see that people who would have otherwise been granted a form of relief and wouldn't have been detained at all are now detained without question. From the moment that the journey begins, the cards are stacked against the Black migrant. Border Patrol is required to speak a bit of Spanish, but that's it. And discrimination is amplified by border protection from the beginning. The messaging that a large portion of African asylum seekers get is that this system is simply not built for you. Priority is always given to Spanish speakers, especially in Tijuana, where they are familiar. And is their home, as one asylum seeker put it. There's no way we can penetrate Tijuana without negotiating. African migrants pay large sums of money to make their way up to the border. And it's a negotiation that needs to happen all throughout the journey with Spanish speakers, especially because by virtue of their Blackness, they stand out. Their safety is also something that they need to negotiate for. Another Black asylum seeker told me, when they see you're Black, they don't care why you want to go to the United States. You need to give them money or they send you back. They give you that fear. They believe you are illiterate from the bush. And what we know about Black asylum seekers is that's simply not true. Although there are a variety of educational levels of African migrants making their way to the border, and they are often highly educated, more educated than their peers, the stereotype is real and based in racism. They must then negotiate with Mexican quasi-institutional groups to negotiate to be able to make it to the US border each day and obtain a number from US Customs and Border Control and Border Protection. The practice known as metering, whereby asylum seekers present a port of entries and are turned back, left to wait for months in Mexico just for an opportunity to start the asylum process, was in effect before the Trump administration, but became a policy in the last 4 years, and has had a real impact on African asylum seekers by extending the time they are forced to wait in Mexico to get a number. This is what a slip looks like for metering, and you'll see the number, and it's a very valued piece of paper because it can impact your relief in terms of asylum as well. While African migrants are in Mexico, they're essentially sitting ducks by virtue of their skin color. They have trouble integrating with the population because of language barriers, and they easily become victims of crime, including theft, sexual violence, fraud. Sometimes even unnecessary identity documents are stolen. And almost every Black migrant that we speak to in detention who has come through the San Ysidro port of entry has been a victim of crime in Tijuana. Simple transactions such as buying food, finding housing, getting necessities put them at risk. One Cameroonian migrant said the following: because they don't understand what you are saying, they would rather steal from you than a Hispanic person. And because of metering and MPP policies of the Trump administration, instead of simply passing through Mexico, African migrants stay so long in Mexico, they have to find work in Tijuana, usually through precarious farming work or industrial plants in order to subsist while they wait for their number to be called. All the while knowing that people who have connections to border officials and are usually of a different demographic themselves are jumping the queue. Black migrants tell stories of their friends and family that were sent back to Tapachula because they couldn't make it financially. And although many asylum seekers, Black and non-Black, are victims of crime in Tijuana, it is almost necessarily the case for Black migrants. So by starting with the premise, as we have in the last 4 years, that everyone on the Southwest border is mandatorily detained, things have gotten worse. The lack of discretion and prioritization for everyone with a criminal record increased criminalization at the Southwest border. What we know is that if your country of origin has less of a tie in the United States, you will remain in detention for longer, even if you are someone who hasn't done anything wrong. The system also presumes that you're a flight risk, which is a racist and false assumption, that because you don't have an established community and flood persecution, you will not appear in court. Black immigrants also stay in ICE jails longer because of massive disparities in their bonds set by immigration judges. If you fled and have weaker ties, If your community is not established, you will spend more time in immigration detention. This is especially true because of the pandemic and the economic toll that the outside community, the people who aren't in detention, have faced. It means that they have less resources to support a family friend or a sibling in detention and are unable to front the bond. Even if you've lost your case and are awaiting deportation, the farther you are from your country, the longer it will take, especially during COVID times, to be able to be deported, which might lend itself to constitutional remedies, but you have to know how to access those and you have to make a petition for those. If you are released on ICE bond, you'll often be released with an alternative to detention called an ankle monitor, which many asylum seekers will tell you is confinement in a different way. They say it vibrates too often, it's too tight, it's a psychological reminder of detention and your label as a criminal. And there's shame and embarrassment if somebody sees you in the public when you're out. One Black asylum seeker told me. So where do we go next? The first step is to treat asylum from a place of cultural sensitivity. This is recognizing the importance of language and language access at every stage of the asylum process. Secondly, ending detention for all and moving away from the criminalization of asylum seekers, which has been a legacy of the Trump administration. Supporting Black communities and organizations that act as sponsors to migrants is also very important in terms of getting people out of detention. Without a voice on the outside, there is almost no way that a migrant can get out of detention. And this is especially true for people who come from further places, such as African migrants and more obscure communities or communities that we don't see as much in the United States or who don't have an established connection in the Southwest region where we work. I'll just conclude by saying that at a time of tremendous hope, we need to be purposeful around our advocacy. We need to have we need to take into account a holistic perspective of what it means for a person to be in detention and not simply fall back on the reality that ending detention is an answer to everything. Because as we've seen, alternatives to detention are also not the solution. And with that, I'll pass it on to Eloise.
Good afternoon. I will be able to, I can start the video because it has to stop it. Okay.
I know Elion is having some technical difficulties. While he is turning on, I think we have him now. Great, thank you.
Good morning. Thank you for being here. This webinar. My name is Leon Lee. My name is Allen Lee, board member of Mauritanian Network for Human Rights. I'm in charge of day-to-day operation of the organization. Mauritanian Network for Human Rights is a U.S. is a non-profit organization gathering Mauritanian immigrants living in the U.S. It is fighting for human rights, civil rights, and better opportunity for Mauritanian, both in US and in Mauritania. The organization work to empower Mauritanian immigrants to integrate socially, locally, and engage civically and fight a better Mauritania, free and racial discrimination, slavery, and injustice. The organization assists Mauritanian by connecting them to important resources in the community they live in, and by assisting them in facing and tackling the issues that matter to them. The organization organize and mobilize Mauritanian community to speak out the issue that affect their life and the life of their loved one, both in US and Mauritania. We work on the local, state, national, and international level on issues including, but not limited, fair immigration and justice, immigrant rights, racial discrimination, slavery, and many other matters that affect the people daily life. We also work to assist in restoring justice for Black Mauritanian living, Black Mauritanian victim of racial discrimination, including but not limited the killing 1990 and deportation, slavery, and human rights abuse at every level. Mauritanian Network envision a world in which every Mauritanian is free from prejudice and discrimination and is armed with the knowledge and ability to lift himself or herself up, to serve, to crave and create a vital lives for their family and community, both here in the US and in Mauritania, now and in the future. From the Global Law and Justice Report, Mauritanian authority continue to restrict freedom of expression and assembly, especially when independent activists protest against racism and ethnic discrimination. The persistence of slavery and other sensitive issues, they imprison activists in dubious charges. In addition to social pressure, a variety of state policy and law that criminalize adultery and morality offenses render women vulnerable to gender-based violence and making it difficult for the woman and risky for them to report sexual assault to the police, government police. Prosecutors in Mauritania use the repressive legislation that include criminal defamation and broad definition of terrorism and inciting racial hatred to censor and prosecute critics for nonviolent speeches. Mauritania abolished slavery in 1981 and criminalized it in 2007. The government claimed that there is no longer a slavery, only its legacy in the form of extreme poverty and exclusion. Slavery has never been eliminated in Mauritania. Mauritania continued to implement biometric national civil registration process for our citizens and others present in the country. Many citizens, particularly the poor and the poorly educated, struggle to fulfill the arduous documentation required for some required. Some have even given up trying to have some documentation in their own country. Schools sometimes prevented unregistered children from enrolling even though school is compulsory from age 6 to 14. Even when education authority allowed unregistered kids to enroll, they prevent them from taking the national exam, which they must pass to continue their education, causing them to drop out school. Many kids in Mauritania doesn't go to school. It's a shame. To this day, there are thousands of Black Mauritanians that have not been able to register in the Mauritanian census, which hinder them from getting official documents and prevent them from doing simple things such as traveling from one city to another city in the same country. Mauritania is a bridge between the Arab Maghreb of North Africa and the darker skinned sub-Saharan Africa. The ruling Arab Berber have higher paid position in job and government, while the darker skinned, Latin, and Afro-Mauritanian are underrepresented in leadership position and face many obstacles in society, from access to education and well-paid jobs. Forced labor of all kinds have a long history in Mauritania, driven by century-old social division. Most slaves have been members of Heritage tribe, indigenous West African, who make up the country's large ethnic group of population, like myself. On the final full days of Trump administration, immigration and custom enforcement deported full Mauritanian to the nation. The Trump administration had once punished for having failed in slavery. These were just one of many deportation flights that departed the United States. In 2018, the Trump administration cut off trade preference for Mauritania after concluding that it had made sufficient progress toward combating slavery. The persecution of Black Africans has been led by Arab Berber minority that rule the country. Nevertheless, the Trump administration continued to deport Mauritanians. A lot of Mauritanians who live for decades in years were forced to self-deport for fear of imprisonment. Many went to neighbor state, Canada, leaving behind their kids who are U.S. citizens. ICE deported 25 people to Mauritania last fiscal year from 98 2 years before. There is usually no way for Mauritanian people deported by ICE to return to the United States in the near future. Mauritania Tour for Human Rights welcomed by the administration approach to immigration to rescind the cruel immigration policy of the previous administration. We call on the President Biden to protect Mauritanian immigrants who fled persecution, granting them asylum or TPS. No more family separation. We call on the President to fight hard, very hard, for the right of Black immigrant who is under view in this fight. For Trump, issue of immigration are always drenched in racism, especially for Black immigrants. To Trump, all asylum claims are frivolous and Black immigrants are simply trying to flee, unquote, the hurt. We ask the new president to change that and let immigrants file their claim. You can get more information to visit our website, which is mauritaniannetwork.org. Thank you.
Thank you, Alion. You've highlighted many, one of the primary issues in terms of representing immigrants of African descent is access to knowledge on why individuals are fleeing, why individuals are seeking asylum. So I really appreciate your giving us details about why people are leaving Mauritania and finding themselves at the southern border. Now we will transition to a Q&A session with all of our panelists. And the first question that I have for Ajmal specifically relates to the cases that have been litigated at the Supreme Court. And I teach at Vanderbilt Law School and I run an immigration clinic. And I have been examining the ways in which the Supreme Court reinforces racism, or not just the Supreme Court, but the immigration system can act in a manner that is colorblind. And some scholars allege that the system's focus on administrative procedures, the focus on challenging deference to national security and immigration doesn't acknowledge the equal protection claims. And so Justice Sotomayor, in her dissent in the DACA case, said, hey, Supreme Court, we should have looked at these equal protection claims. And the Chief Justice Roberts made a really, his opinion focused on the Administrative Procedures Act. And then in a short paragraph, he said, we don't need to evaluate the equal protection claims. And so can you talk to us about how does it impact immigrants of African descent, Black immigrants, when equal protection claims are ignored? What signal does that send to immigrants, especially Black immigrants, when the Supreme Court doctrine focuses on procedure versus discrimination?
Professor McAnders is exactly right. Both in the DACA case as well as in Hawaii v. Trump, the travel ban or Muslim ban case, the court specifically rejected the claims of invidious intentional discrimination. Now, this is problematic for a variety of reasons. First, the court has created an extremely limited definition of what counts for intentional discrimination, where you essentially need this smoking gun proof of evidence, where you need someone saying that they took bad action because of someone's race or other protected status. And even, in both of these cases where we have the president, calling individuals from Mexico, criminals and rapists, and we have the president saying that as soon as then president saying as soon as he's going to come into office, he's going to call for a complete and total shutdown of Muslims entering the United States, and then that's in fact what he does. And the court in both cases, both in the DACA case and both in the Muslim ban case, says, that's not good enough to count for the purposes of intentional discrimination. So it really leads to this question: if those aren't good enough, what is actually good enough to count for intentional discrimination? And that leads to Professor McAnders' larger point, and I think we've seen some of this over the last month, is if you promote ideas that a certain large segment of the population is not as good as the rest of the population, that's not without consequence. I think that has played a role in, unfortunately, what we saw on January 6th, where you have another portion of the population that is emboldened to take violent actions that are based in large part on a belief of white supremacy.
Definitely. Thank you for that response, Ajmal. I wanted to ask Ambreen and Alion specifically, what steps can be taken to assist Black immigrants who are in detention? Ambreen, you mentioned that organizations and individuals should sponsor immigrants. I know we have a wide variety of individuals who are listening in. What does it mean actually to sponsor an immigrant? And Alion, if you could speak to, I did a Fulbright where I taught in Morocco for a year and worked with immigrants from what we call sub-Saharan Africa, and realized that there was a form of racism there. Can you talk about how an individual gets to the southern border from West Africa and what that looks like, what the journey is like, so that our listeners and viewers can understand how you get to the southern border?
The journey is so difficult from Mauritania to the United States. Going from southern border is very difficult. People in Mauritania, when they leave going to Brazil, taking the path going to the United States, some are risking their life. We have a couple of deaths from our citizens living in Brazil coming to the United States. It happened. It's a hard journey, but people are not fleeing Africa or Mauritania for poverty or something like this. They're fleeing racism, slavery, discrimination. It's very tough and hard. Coming from the southern border, many Black Africans encounter a lot of problems. Like what Ambreen said about coming from the southern border. If you don't have money, you can't even get in. You have to. Most of them have to stay there in Mexico, work, try to find a job in the United States. It's very tough and hard.
Thank you, Ambreen.
Yeah, I guess so. Sponsorship is definitely one of the best ways to prop up a person who's in detention, in that in order to be released, you have to show ties to the community, and an established community helps for sure. So sponsorship, what it looks like is providing financial support, showing that you have status in the United States. So a person would have status in the United States in order to sponsor, for the most part, and would have to be able to attest to ICE or the court that the immigrant would need to, that they would help facilitate the immigrant in attending their court appearances and participating in ICE check-ins and so on. And that's part of the reason why it's so hard for people, for example, who are from Mauritania. We're seeing more and more migrants from Mauritania in detention, or we have in the last year than I think we have before. And because it's a newer or younger community in the United States, it makes it even harder for these people to get out of detention, because it's not necessarily the case that they have a connection to someone on the outside who has who is able to attest and who is able to provide financial support throughout the process.
We have a question from an attendee, which I think goes to one of the issues that has come up with the family separation case. I think most people are unaware that the face of the ACLU case that was brought against family separation involved a Mrs. L, who was an immigrant from the Democratic Republic of Congo. And she was separated from her child at the southern border. I don't know, Amberine, if she came in at the Otemese facility, or I know it was around San Diego, and her child was sent from California to Chicago while she was being prosecuted under the Trump administration's policies. And so this leads to our attendees' questions. Are there any resources that we can use to employ the correct language in anti-Black asylum messaging? What can we do to kind of counter the narratives that are being placed forward? And this is for all of our panelists that relate to anti-Black asylum messaging.
I'll just say in a really practical sense, and this speaks to something that was brought up in the chat. Black asylum seekers in detention don't have many attorneys who are Black that are able and who are representing them. So we are always, our organization is always looking for people who are Black and who are of similar communities to the people that we see in detention to represent those people, and we're looking for people to do that, on a volunteer basis. So that's one of the first steps, I feel like, towards achieving the goal.
The judicial system in the United States for Black is very hard. It's very tough. Black immigrant, even tougher. One of the things we can do is have more resources, more community, more meeting, more fundraising to help those Black immigrants get out of jail. My organization, we helped free 25 Mauritanians last year alone. With the help of sponsor, with the help of those fundraising, we secured those, we helped those Mauritanians free. And to free them, you have to have a sponsor, and the sponsor have to be someone who have enough resources to accommodate those people. It's tough, but we Black immigrants need help for that.
I know we're at time, but I want to ask our panelists a question. One question that I have been kind of mulling over as a professor and practitioner of immigration law is the concept of developing transformational solidarity. We see that anti-Black racism has many facets. And so I wanted to, as a conclusion, get from each panelist, how or what steps do you recommend our viewers, what can they take to be in solidarity with Black immigrants and to develop this concept of transformational solidarity as we kind of engage how anti-Black racism impacts Black immigrants in this country? We'll start with Ajmel, Ambreen, and then we'll go to Alion.
Great. So I think LDF works on a lot of big national issues or in national cases. And I think that, I'd be happy to talk more about any of our litigation, but I think the reality is that immigration enforcement or treatment of immigrants is also a local thing. I mean, each of your municipalities in which you live has policies, or maybe they don't have policies, which can be insightful as well as to what the role of local police is with regards to the enforcement of federal immigration law. I think there are a number of associations of police around the country, including the major cities' chief police association, that have been, very clear with regards to the fact that local police shouldn't be involved in the enforcement of federal immigration law. But these are important things that you can take up at community meetings, at city council meetings, to see what the policy is if your police department, what is the detention policy of your sheriff's department with regards to holding people for ICE when there are ICE detainers out there for them, and really sort of impact what your community is or is not doing with regards to local police and local sheriff's departments facilitating the work of ICE.
I think for the work that we do, like I mentioned, representation is really important, but also supporting community bond and bail funds that target these populations, and awareness and spreading awareness about who's in detention is huge, because that's where we get a lot of volunteers who are able to provide language assistance and pro bono representation for these communities.
Black racism is here. Immigrant, particularly Black immigrant or immigrant in general, fear. They fear when they get detained, they won't have the protection like other people in jail. I'm coming back to just the same thing I was talking about, resources. We need some resources. We need advocacy to talk about the issue of immigration, especially Black immigrant. The immigration reform, that's what the new administration should follow, and then we need that to pass. So most of our citizens from Mauritania who are here in asylum, most of the cases have been denied because of language barrier. The language barrier makes the case been denied, but most of the cases are legitimate. And we just need help. We need a lot of help from the community and advocacy and those groups.
I would like to thank our panelists for joining us this afternoon. I invite you to continue the conversation with the American Bar Association's Immigration Commission and me next week with the next in our series of examining anti-Black racism and immigration with our panel on the prison to deportation pipeline, crimmigration and Black immigrants, which will be at the same time, next Wednesday on February 10th. And that webinar will focus on how immigration enforcement is absent of many of the protections that we see in the criminal justice system, and how that results in heightened detention and surveillance of Black immigrants. So please join us next week as we continue this conversation. And thank you for the panelists for your time and your insightful comments and educating us about this issue. Thank you.
Thank you.